Hey, and welcome to another episode of Suits and Boots Legal Talk. Today, it's all about trust. So today, we're here with Kolin Funk, one of the associates at Bimbo Davidson & Martin. My name's Luke Martin, one of the partners there, and thanks for joining us for another episode of Suits and Boots Legal Talk. I said we're talking about trust, but I don't mean like just the trust that maybe you have in listening to this podcast.
That's right. Well, it's different. We trust each other, but we'll get into it.
However well-founded or ill-advised
that's right.
Be,
we'll let you decide.
But it was funny. We were joking before we started recording how at the end of all of these podcasts, and if you've never made it to the end, maybe this would be a good day to do it. So it's funny. You look at our Facebook videos, and it gives you the outline of what people listen to. An average time listened is something like a minute and a half.
Yeah.
So it's a little discouraging because these things are longer than that.
Well, we got to make that minute and a half the best we've ever done, I guess.
So if you're not, I guess if they're only listening for a minute and a half, if that's the average, then we must be only entertaining for a minute and a half.
That's right. We got to figure out how to make our whole spiel fit into a minute and a half here. And here we are wasting our minute and a half. Dang it.
Oh, man, you're right.
Well, see you next time.
We're at a minute 12 seconds. So
15 seconds.
We've got 15 seconds
Trust,
to redeem
good.
this thing.
Get one.
All right. So today we're talking about trust. So we try to keep these things that we've been talking a little bit, and we talked a little bit this morning about how we try to keep these podcasts educational. And people, you guys have things going on. You're busy. You don't necessarily have a lot of time to sit around and listen to us just kind of BS for 30 minutes. You got more important things to do. So we really appreciate you guys tuning in, and we want to respect your time. So we try to keep these things educational, but also a little bit entertaining. Yeah. So hopefully we strike a good balance with that, and maybe we should stay on topic now.
Well, let us know. Let us know what you guys like. We're here for you. So.
Absolutely. So put it in the comments if you want to hear more of the stuff about tractors and
whatever,
crazy stuff. Just, we'll be happy to talk about that too. So, but today we're talking about trust. So what is a trust, Kolin?
So a trust is kind of a quasi estate planning technique. It's on par with like a will, or and sometimes people use LLCs to do their estate planning. But today we're talking about a trust. It's a good middle ground for a lot of people, and it's not going to be right for everybody. But a trust is essentially a contract between you and a person called a trustee, and that person can be you in some situations. Sometimes it can't be you, but it's really an agreement with this trustee that you're going to transfer your belongings to them, your assets to them, and they're going to hold on to it for whoever's benefit that you want. So it could be your own benefit, your kids' benefit, the benefit of a charity. The sky's the limit on this, but essentially it's a legal relationship that's created between you, the grantor of this agreement, and a trustee who's going to hold on to this stuff after you die and carry out your wishes with these things.
I'm trying to remember who it was, but it seems like it was a politician years ago, and maybe we read it in law school. I can't remember, and maybe you will. But there was somebody who said not trust. They said corporations are people too. Do you remember? Have you heard that quote?
Maybe I can't
remember where it came from, but they said corporations are people too. And in the legal world, that's kind of true.
It is, yeah.
Because we treat. So if you own a company, we treat you and that company as separate individuals.
Distinct, yeah.
They're not the same person. That company has its own, lots of times, employer ID number, and taxes are different, and you are a separate person. Trusts are kind of the same, right?
They are, yeah.
Separate. It's kind of like a corporation. It's a separate entity.
That's what when people come in, I say if you can kind of imagine it, it is a legal person that's being created, and that's the person who owns these assets, and the trustee doesn't necessarily own the trustee doesn't own these assets. The trustee is really just the person kind of telling the legal person what to do, and the trust listens to them. With a lot of times. How we set them up, the most common kind of trust we do, and we'll get into the different types of trust just briefly. A revocable trust is essentially, you transferring your assets from yourself personally to yourself as the trustee. So if you can imagine taking $1 out of your left pocket and putting $1 in your right pocket, you take off your personal hat, you put on your trustee hat.
Yeah,
that's kind of how it works.
So it would be like if you owned a car and you owned a company. and you own the car in your name, but you were the president of the company, you just take the car out of your name and put it into the name of the company.
Yep.
And you still own it because you own the company.
That's right.
But
Same kind of deal.
Yep.
Same deal.
So now now it's just the car goes into the trust, and
That's
you
right.
still own it because you're the trustee of the trust.
Yeah. Functionally, a lot of times, in most situations with revocable trusts, your ownership, technically changes who owns it, but your ability to make decisions, sell these assets, transfer these assets, modify these assets, do whatever you need to do with them, doesn't change. You're still in the driver's seat on that kind of thing.
Okay, so if we create a trust, we've just basically created an entity, whether it's not a company, it's a trust, but we've created an entity that you can transfer all of your assets into.
Yeah.
Why? Why would you do that?
Yeah, it seems kind of counterintuitive. You want to build your own wealth, and it's not necessarily getting them away from you, but yeah, it's most frequently what we find most people could most benefit from a trust is for probate avoidance, and we've talked about probate in some of these episodes before. It's a bear sometimes. It is inconvenient. It takes a long time. It's public. A lot of people don't like the fact that it's public, and you pass away and all of your stuff's passing under a will. That will's going on file with the courthouse, and any person off the street can go in and with the accompanying estate documents, they can see exactly what passed under your estate. They can see down to the penny who got what. So a lot of people don't like that, and it is a little bit disturbing that your private assets that you worked for your entire life can be on full display, and anybody can walk into the courthouse and see exactly what passed.
Not only that, but in that estate file, there's going to be the death certificate, which contains Social Security number and all. I mean, pretty much everything about the person is in that estate file.
That's right. So by way of doing a trust, essentially, if it's set up correctly and funded correctly, and we'll get into what funding is essentially, you don't need to go to the clerk. A lot of times what will happen is, the person will pass away, and then, your executor or your loved ones will essentially kind of take stock of what you own and say, oh, well, he had the trust here. Everything he owned was in the trust. So, when I, the person, pass away, nothing is passing under my estate. The trust already owns it all, and the trust as that distinct legal person continues on.
And knows what to do with it.
Knows exactly.
Because you've given instructions.
Yep, in that document.
So one big, huge benefit, and maybe one of the biggest benefits, is that probate avoidance. So secondly, let's talk a little bit about where trusts are almost like the golden ticket, is where we have multiple properties and multiple beneficiaries.
Yeah.
So we just did one recently where our client had property out of state and had property in another state, and he had some property that wanted to go to this child and some property to go to this child, and then companies and businesses.
Yeah.
Talk about how trusts are so useful in those contexts.
Yeah, I mean, it's really just a matter of you can lay out as specifically or as broadly as you want this kind of property to change, and that's not necessarily distinct from how you could do it under a will, but it really just gives more flexibility. It allows your trustee to do what they determine is best in that situation. If it makes more sense to distribute this property in kind, or if it makes more sense to sell this property and distribute it, it really just allows your trustee to be the one who can kind of act for however is most convenient for the beneficiaries, rather than with a will having them your executor have to go through, and get okays from the clerk and follow kind of rigid standards specifically for selling real property. So I tell people it's a little bit more work on the front end with funding. But once you get it done, it's your ticket to ride, and it can be, if you're doing a revocable living trust, edited and amended as freely as, or revoked for that matter, revocable, as you need it to be. So
one of the coolest cases that we've had come across our desk, and you and I have talked about this, we had a client come in and their family, so we've got this heir property, and heir property is just property that's been handed down through multiple generations, and now maybe there's several. You just did one where there's like 40 some heirs that we have to work with. In this case, there's not that many heirs, but there are several heirs, and this house is one of the oldest houses in its area. And the family really enjoys the property. It's on a farm. It's on, I believe it's on maybe one of the rivers here, or there's a major creek, and they just go and they have family picnics, they have family reunions there, and they don't really want to sell the property. They never want it to be sold.
Yeah.
They want to keep it in the family. They want the family to be able to enjoy it. What can they do? And it seems like a trust is a good fit for that, right?
Yeah, and that is the thing. A trust can kind of terminate at a certain kind of triggering event, or it can just kind of remain in, not necessarily in perpetuity, but there's workarounds to get things to be held in trust. For
What do you mean by perpetuity?
You can't leave something in a trust forever. There's what's called a rule against perpetuities. And ask me what it is. We'll have to have another podcast about it. I'll have to do my homework on it a little bit more. But it's one of those things. It's kind of
it's the bane of every law student's existence.
Yeah, it's one of those things that is you just hope not to have that come across your desk. A rule against perpetuities issue. Google it, and you let us know if you think it makes sense. I'd be happy to hear you making heads and tails of it. And that's not a slight at you in any way. I struggle to make heads and tails of it sometimes.
Focus. Okay.
So long story short, yes, a trust can be good for that kind of thing too, to where, as opposed to a will, you pass away, and that stuff's going to have to get wrapped up and given to those beneficiaries, those heirs, as quickly as possible, or else the estate's not going to be able to be closed. Counterbalance that to what a trust does, and a trust you can carve out exceptions to where you can leave this trust open for a good amount of time for whatever reason you see fit, really. If you want it to remain in the family and you don't necessarily want one beneficiary to get it, then we can put it in a trust, and it can be preserved for
future
generations for the peaceful family spot that you like to go to, and you just want it to stay in the trust. You don't want there to be fighting. The trust can hold on to that.
Yeah. And then you can have one person named as the trustee to manage that asset, as opposed to maybe 10, 15, 20, 30, 40 heirs that would have to manage it otherwise.
That's right. Yeah. And that's what it doesn't necessarily mean that the trustee can only make decisions by them. They are the decision maker for the trust. But that doesn't mean they can't take, input and take into consideration the situation of the beneficiaries.
Yeah. And then so we've got probate avoidance. We've got this situation where there's multiple properties, multiple heirs that maybe you want to do different things with. There's flexibility with a trust.
Absolutely.
And then if we've got a legacy property like that house that we're talking about, or something like that, where you want to preserve that asset for years and years down the road. So those are three big benefits. Another benefit that I'm thinking about is the ability to state in the trust what you want. So you talk about taking input from the beneficiaries, and thinking about the trustee makes these decisions. But with a trust, you can also stipulate in that trust, give the trustee specific instructions, here's what I want to happen in different triggering events, right?
Yeah, no, that's it. It is highly customizable to whatever your situation looks like. A lot of people, the most frequent thing that I recommend to people when they're doing this sort of thing is, you have young children, which incredibly important for you to set up a trust if you have young children or something to.
And maybe that we've talked about how it's so important, and I don't mean to interrupt, but we talk about, we think about estate planning and wills and things like that for older folks. But ultimately, it's so much more important for people mine and your age to have that estate plan in place, and especially a trust if you have minor children, right? Talk a little bit about that.
So with that, kind of the alternative to having a trust here would be, you just get a will and you say, I want everything to go to my kids. Problem is, your kids are 10 and 12 years old, right? And you own a house. If you're under 18, you can't own real property. So we come into the issue of, you tragically pass away, leaving behind a 10 and a 12-year-old child. And the will says, yep, they're supposed to get real property with no sort of, trust or anything laid out that would kind of help resolve that discrepancy there. It is a massive undertaking to get that kind of issue figured out. You're going to need to get a guardian appointed for those kids. You're going to have a superior court judge sign off on a lot of things, to where, as opposed to a trust or another mechanism where that wouldn't be the case. So it really is when there's minors who are coming into property that it can be an issue. And the benefit of a trust here is that, as opposed to this will leaving it directly to minors, it's in the trust. The trust continues on, and when those kids reach a certain age, you mandate that the trustee distributes those assets to them. Most frequently it's, some people say they're 18 years old, they can have it. Some people don't feel great about giving an 18-year-old a 1,000-acre farm. I get it. Some people don't feel good about giving an 18-year-old, a life insurance policy or a large chunk of cash.
Or their Corvette collection.
There is an endless amount of stipulations that you can put on this. You want to give it to them in increments. You want to give it to them outright when they have their first child. You want to give it to them outright when they get married. You want to give it to them outright when they graduate college.
Or really, at a different age besides 18. Maybe you say 23, 24, 25.
And the sky is really the limit on when you want to give these things to, when you want the triggering event for the trust to wind up is kind of what the closing process of a trust is called. Or, like we said earlier, you can kind of let something remain in semi-perpetuity until, a triggering event happens, at which point, you kind of lay out what you want to happen once X event happens, and this is how your trustee is going to be bound to distribute this property.
Yeah, sure. So when we talk about the trustee, let's talk, if we've got a revocable trust, or really an irrevocable, but most of the time in a revocable trust, that's the person who is the creator of the trust. Mm-hmm. So if I wanted to have a revocable trust, I would be that trustee, right?
Yeah, you would probably be your trustee. That's the only reason I would think you'd need it. If you don't want to be your trustee, let's just put it in an irrevocable trust. But yeah, that's most frequently what we see, a revocable
so
trust.
Talk about the trustee just a little bit. What's their role? Who is it?
Yeah.
Who can do it? And what are their responsibilities? How do I know they're not going to just take the money and run?
Yeah. So if you're your own trustee, you probably don't have to worry about hoodoo and yourself, right? Yeah. So we'll just say
and if you do, we're not the people to help you.
Yeah. Good. So in the situation, let's say we set up a revocable living trust, and then we have young children. I as the trust creator and the initial trustee pass away while my children are still underage. I choose Luke here to be my trustee as just a buddy of mine, right? He's a trustworthy guy. He's a trustworthy guy. I know he's got the best interests of my family in mind.
Trustworthy. I see what you did there.
That's it. So what would essentially happen is I'm going to need to talk to Luke about it. Say, hey, I've set up this revocable living trust. I'm going to be the initial trustee while I'm still alive. In the event that I become incapacitated, so I'm still living, I just don't have legal capacity to make my own decisions, or I die, will you be my trustee? And Luke will say, well, what does that mean? I say, well, a trustee is essentially someone who owes a fiduciary duty to the trust, to the beneficiaries. And really that's a legal term for someone who has a very high responsibility of taking care of and putting the interest of the beneficiary and the interest of the trust before their own. It's a contractual obligation, and fiduciaries don't do a good job, then there's repercussions legally for them.
Yeah.
But yeah, it's really a person who is promising to you by way of taking on this office that they're going to put the interests of the beneficiaries, even if it's counter to their own personal interests.
Can anybody do that?
If you're over 18 and you trust them, yeah, anybody can pretty much be your fiduciary as long as they have capacity.
Doesn't have to be an attorney, doesn't have to be a banker, accountant, none of that.
Yeah, it's obviously you need to pick someone who is responsible, someone you trust. A lot of times what'll happen is for revocable trust, you're creating it as a couple. You and your spouse will be the trustees initially, and then when you pass away, just to get if there's still minors who are entitled to property, there'll be someone who can step in. But if you get to the point where your children are of age to take these things, you can name your children. It's not prohibitive to be a trustee and a beneficiary. Really, the only limitations that get in there are when all three people are the same. The three parties to a trust: the person creating it, the trustee, and the beneficiary. That can't be the same person. There needs to be at least one other person in one of those categories.
So if it's probably a good idea if you're friends or have an accountant that's a buddy or an attorney that's a buddy or a banker or something, those folks typically make good trustees, but it doesn't have to be one of those.
No, it does not. It does not have to be, one of those people. No.
Yeah, yeah. So you've talked about beneficiaries. Talk a little bit about that's kind of a fancy word that we use a lot in our office, but the folks out there might be thinking, what in the world is a beneficiary? So talk just a little bit about what that is.
Yeah, it's really just the person that you're selecting to, derive benefit from the trust, and even in simpler terms, the person you want to get your stuff.
Yeah.
And that's as straightforward as it could be. For whatever reason, you're selecting this person, and it's your trust. It can be anybody. You can make a charity, you can make your church, you can make your pet if you wanted to the beneficiary of a trust. You can make your kids, your aunt and uncle, grandma, grandpa, your childhood friend. Anybody can be your beneficiary, the person who you want to get your stuff. So that's kind of the fancy, not so fancy way of saying what a beneficiary is.
So as we think about trust and we think about all the benefits, probate avoidance being one of the big ones, if you have minor children being another really big one. So we're really thinking about planning for our death, right? Where this is estate planning is really what we're into here. So talk about what happens with a trust. If we're going to avoid probate, what does happen when I pass away? If I've got a trust, well, even before that, let's talk about something that's even more important, funding the trust.
Yes.
So isn't that's something where the ball gets dropped
all the time?
All the time.
The worst possible thing in the world, and it happens unfortunately all the time, not by the people that we advise, obviously.
Yeah.
People create a trust. They hear, I need a trust. So they go to an attorney and they get a trust drafted up, and the attorney does their thing and they draft the trust. The person signs it and the person leaves and they think, I'm covered. I have a trust. I'm done. This is why I said earlier, it's a little bit of legwork on the front end. But funding the trust is really the most important step here. You actually have to transfer your assets to this legal person, the trust. So your house, you have to do a deed from you personally, from you and your spouse personally to the trust. And, in a revocable living trust, you're essentially doing a deed from yourself personally to a deed to yourself as the trustee.
Yep.
And obviously there's terms in the trust that kind of lay out successors, me first, and then when I become incapacitated or die, then Luke.
Yeah.
And that continues on. But yeah, funding, you need to transfer these things from your name personally to your trust. And with most personal property, it's pretty straightforward. Your furniture in your house, you don't need to write up a bill of sale. We'll include that in the kind of scheduling part of the trust. There's a form on the back that we can just kind of attach some of that to.
But maybe bank accounts, cars would be a big one.
It's things that are titled, things that are governed by like banking rules, the FDIC and stuff like that. Bank accounts need to be either, put into the name of the trust or made pay on death to the trust. That's okay too. Cars, you need to retitle those in the name of the trust. And if you don't do these things, essentially the trust is, it's non-operative. If there's nothing in it,
you don't get the benefits of the trust if you don't do that.
If there's nothing in it, then the trustee has nothing to distribute. You can have beneficiaries. They're just not going to get anything because there's nothing in the trust. Yeah. The trustee cannot, just by way of setting up the trust, cannot do anything with assets that you don't put into the trust.
Yep. They can only do things with assets in the trust. So let's say you've created the trust, funded it like you should. So you've put all of your assets into the trust, and now the person dies. What happens with the trust? What's the next step?
Yeah, I mean, it really just depends, entirely on what your terms are of that trust. But more often than not, for estate planning purposes, we'll just say the trust says my kids are to get everything, and my kids are over 18 years old, and that's what I say. At that point, the trustee will, without any interference from the clerk of court, take what's called a certification of trust around to all these places, your bank, DMV, an attorney to get a deed drawn up, and they'll say, I'm the trustee of this trust. They can choose to show them the long form document of the trust. They don't have to. That certification of trust should be sufficient to do everything, which is just kind of a one sheet thing they can kind of show. At that point, they can go on to doing a deed to the beneficiaries, getting the vehicles transferred over to the beneficiaries, getting all that money out of the trust bank account and go over to the beneficiaries. Or, another scenario would be something where, the kids are still underage and the trustee will essentially manage those assets for the children. More often than not, what we do is like care, comfort, maintenance, support, those kind of things, generally, to where it gives the discretion to the trustee, gives them wide latitude to kind of distribute money for those minors, to essentially continue having the same quality of life that they've been accustomed to when, presumably their parents were alive.
And ultimately, you want that trust to continue to pay for college and things like that.
Anything, they need a new vehicle, obviously within reason, or not. It really just depends on
discretion of the trustee.
It depends on what the trustee's feeling. That's why it's paramount to get someone you trust. But yeah, it's going to be on the trustee at that point to essentially step into the financial role of like a parental relationship.
This sounds like a lot of work. So the trustees get paid or no?
They can take a commission from the trust, and that's something that we'd want to lay out in the terms of the trust here.
The person who creates the trust can decide how much they get paid and that kind of thing.
Yeah. So it is a little bit of work, but really it can solve a lot of problems for a lot of people on the back end. The way I think about it is that if you kind of are on the fence about a trust or a will, just doing a regular will, just sit down and look at your assets. Come see us. We can kind of help you decide what's best for you, because a trust is not going to be right for everybody. It wouldn't hurt for everyone to have one, but it's not necessarily right for everybody. The comparison when you're looking at estate administration versus trust administration, which would essentially just be the difference of the clerk is monitoring estate administration and there's no government involvement with trust administration. It is pretty common knowledge that if the government isn't involved in it, it's probably going to be simpler and more streamlined.
I'm from the government. I'm here to help. That's the right? Yeah.
So there's a lot of things that go into it, but yeah, I'd say trusts are a great tool for a lot of things, and no two trusts are really going to be the same kind of deal. They're very customizable, and really we're just scraping the surface on what you can do with trust. There's a lot of things you can do.
Let's talk just a little bit about a couple of concerns that I've had brought up to me as an attorney. Like, well, if I put my property in trust, I'm going to lose control of it. Right? Because we saw this, actually, my family has talked about this. There was a large farm that we were familiar with where the ancestors had put the property in trust, and it was kind of locked down. And the people who owned it, the people who lived on it, the beneficiaries, couldn't do much with it. Mm-hmm. They couldn't sell it, they couldn't mortgage it, and it really was a hardship for them because they still had to pay the taxes on it and all this stuff, but they couldn't do anything with it. So you can lock a trust down too much where it's not useful.
Definitely.
But in general, if someone transfers their property into trust, do they lose control of it?
I mean, no. If it's a revocable trust, the person who's transferring that property into there has complete control. Like we said earlier, if they do it one day and they wake up, a week later and say, I don't want to do that, they can just as easily go and revoke that whole document and get everything transferred right back out to them.
Yep.
What I will say with revocable trust is that, the person creating it, they're the person who can revoke it. When that person dies, that trust kind of becomes irrevocable at that point. It's kind of set in stone. And
so whatever they said to happen, that's what's going to happen.
And that's what, if that's kind of the other side of that rule against perpetuities we were talking about here. If they do something that is against what, the best interest of the beneficiaries is, that rule against perpetuities is kind of in place to catch that kind of thing. So this property doesn't stay, unsellable for eternity. Generally, that's what it's for.
And that's stuff we would have to talk specifically about, and every situation in that case is going to be really different. The other complaint that we hear a lot, or that I've heard quite a bit, is, oh man, trusts are just so expensive. And they are more expensive than a traditional estate plan. But they're a lot less expensive than estate administration through the court system, right?
1,000%.
Well, maybe not 1,000%.
Sometimes, I don't know.
No guarantees here, folks.
Very certainly, yes. Getting a trust, it's more expensive than doing a will on the front end. I will say that. It's not absurdly more expensive. It is more expensive though. But the benefit derived to your beneficiaries and your executor in terms of time and financial commitment and the amount of money that is going to the state, you will save in the long run by doing a trust in most situations. Sometimes it won't be the case. And that's, I'm not gonna, if you come and see me, excuse me, I'm not gonna tell you we need to do a trust immediately. We're going to talk about it. If it's not right for you and the cost benefit doesn't work out for you, let's just do a will. I mean, sometimes they function out to be the same deal. But a lot of times if your concerns are probate avoidance and not having anybody but your trustee make calls for your estate, a trust is the way to go for sure.
Yeah. And then the one benefit I can see is it just everything being private, because so many folks that have a lot of assets or something like that, they don't want the world to know.
Yeah.
And if you have to run that stuff through an estate, the world's going to know.
And that's one thing I was speaking with someone about it the other day. It's like, especially if there is, let's just say you have a will and everything goes to your 18-year-old son, that's going to be on file. You don't want remote members of your family, people you never talk to, just saying, "Oh wow, this 18-year-old kid just got $250,000."
Yeah,
I could help him manage that.
Oh,
Some wayward cousin or aunt or uncle that says, "Oh, you don't know how to handle that. Let me handle that." This trust, it is completely private. They can ask to see your trust, but you say, "No, no, I'm not going to tell you." Yeah. So there's a lot of benefits to it. It generally is a great estate planning mechanism.
Most of what we've talked about today, as we kind of wind things down, has been about revocable trust, meaning the person who creates it has a lot of power to create it or dissolve it, to move property out of it. It's really easy.
Yeah.
There are other types of trust out there, right? That the irrevocable trusts that are more locked down. Mm-hmm. Those things we really need to talk about a lot before we set into some other type of trust.
Yeah,
right?
I mean, it's kind of like getting a tattoo. You really want to be certain that you're going to like this tattoo. That's kind of what you would equate an irrevocable trust to. Once those assets are in there, and you pick your trustee. The trustee is the one managing those. The trust owns it. You can't turn around and say, "Hey, I want those back." The trustee's going to say, "Well, actually, you made me your fiduciary, and you said this is what you want done with those, and we executed it. So
it's done."
No, I can't. I'm sorry. It's going to get them into trouble if they just let you kind of welch on that agreement. Irrevocable trusts, like Luke said, we'd really need to sit down and have a conversation with those. Those definitely are not a one size fits all deal. There's countless different types of irrevocable trusts in terms of what you're trying to do. But generally, I'd say there's a pretty sizable federal estate tax threshold. So it's, I think, around $14 million right now. So if your estate is greater than $14 million, come in and see me, and we'll have a conversation about doing an irrevocable trust, and that's to get assets out of your name, so that your assets that you've worked hard for, $14 million. The Uncle Sam federally doesn't get a cut of that pie. We can kind of work
here to help.
Yeah, we can work our way around that. Another reason that we may want to do an irrevocable trust is for Medicaid planning. And we've talked about Medicaid planning in the past, to where the crux of Medicaid is that they'll take you on, they'll pay for your stuff while you're alive, but when you pass away, they're going to put a claim against your estate to try and get paid back. If we can respect the look back period that kind of goes with Medicaid, we can transfer your belongings, your house, into an irrevocable trust. And again, it kind of gets locked up in there, but that's really what makes it go.
Yeah.
For that situation to where Medicaid can't come back and say, "Oh, well, you have a house, it's just in this irrevocable trust," and you say, "Well, I don't have control over it. You can't put a lien against it," and that's how it works. So for those are the two of the biggest situations that would apply to a lot of people, a large number of people: Medicaid, lien avoidance, and that avoiding that estate tax threshold. And again, like I said, there's a ton of other types of irrevocable trust. It really is just a matter coming in and seeing us, and we'll pick something that's going to best meet your goals.
That's it. So make an appointment. Come see us. And unlike the government, we really are here to help.
That's right.
To make things easier.
That's right.
And if you come see us early, come see us before you need us, we can really make things easier. So we can help to smooth all these things out and make it to where when these estates happen, when people pass away, these assets can be transferred fairly seamlessly.
Yeah.
So we really want to help with this stuff. And we always, we were joking before the podcast about how at the end there's always this disclaimer that says, we nothing here should be construed, blah, 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 as legal advice or whatever, because all these situations are so different.
Yeah.
And so we try to talk generally here. For specific situations, you got to come and see us. And so we want to help. Like and subscribe to this channel. Check us out. Make sure, look at all the videos that we've got, because we've got estate administration videos. We've got estate planning videos. Now we've got a trust video.
Yeah.
So, just check these things out.
And you kind of see what we see here, and that this stuff is all interconnected. It's crazy how much these areas of the law overlap with each other.
They do.
So. Check them out. Let us know what you think of them, and we'll keep them coming.
Yeah, thanks for watching, guys.
The information contained in this video and audio recording is general in nature and should not be relied upon in making legal decisions. Every situation is different, and you should consult with your attorney before making any legal decisions.